everyone. Welcome to the series of interviews with cybersecurity experts at Cyen. I am your host, Eva Tasheva, Cyen CEO, and today we have a data protection expert joining us to discuss the interlink between data protection and security. Aisatu Sar, hello, welcome.
Hello, Eva. Thank you. Nice to meet you. And thank you for inviting me to have this little discussion with you. It's a pleasure.
Aisatu, we've met at another event. She was a very inspiring speaker, so I invite you to follow up with us and listen. She's a data protection officer at Lombard International Insurance, which is part of Utmost Group. But she's also lecturer at universities in Paris, in Luxembourg, in Senegal. She's also a book author. You see the link to the book. Maybe you can check it after the discussion. So you have vast knowledge on the topic and you have spent a lot of time reflecting, but also practicing, working on the data protection issues at stake today. We know the industry insurance, but also European economy in general is digitizing to unprecedented scale, and much of this digitalization today is going in AI, some new field of development. How do you see the main points of conflict between the rapid advancement of AI technologies and the existing data protection regulations that we have in Europe, like the GDPR? Do you have examples of these tensions?
Yes, it's really a very relevant question in a way that now GDPR it's quite well implemented since now we have few years now ahead with this regulation, and the AI is indeed a new topic in a way that now it's really involved within all the company which are aiming to go and to develop their AI system or use the AI system. And sometimes some of the company are not really understanding how it could conflict with the other regulation which are in place. And from a data protection perspective, it's something which is harder in a way that AI, in order for the system, for the tools to work, we all know that it needs data. It needs data, which could be like commercial data, any kind of data, but most of the time, personal data to work, to deliver, to train, and to learn all the algorithm in order to be able to deliver the proper feedback that the company is expecting, the individual are expecting. So, and here, the issue that we can face, and which is like a bit giving this conflict between AI and GDPR, is that GDPR, it's a regulation where the goal is to empower the personal data, empower the individual about how companies are using their personal data. So it's giving like a lot of principle, like the transparency principle, the fact that we need to have a legal basis in order to process the personal data. We need to ensure that the purpose of the processing activity is clear. And the issue that we have with AI is that most of the time we don't have a real purpose, because we are using the system, but we don't know in advance what we will do with the system. We don't have like real transparency, because when we are using the system, we don't know how algorithms are trained behind. So that means that using AI system sometimes is giving a gap between what the GDPR is expecting the company to do and what the AI system is provided. So we can take examples. So for the time being, the examples I can provide are the one of the Italian Supervisory Authority, Il Garante, who already controlled and fined some AI service provider. So here we will have two different ways to see. So directly the issue that we can have from a AI provider, so the company which are developing the AI system and then giving access to the AI system to company, and the issue that we can face when we are just a user, so a company using AI system and not having any power on how the AI system is working. So for instance, if we are focusing on the Il Garante feedback that we have for the different sanction, control and sanction that was performed, we can focus on two, which are like, I would say, interesting. The one against OpenAI in 2023. And we can focus as well the one against Replika service, which is an AI chatbot. Same in 2023. And for both of the companies, the supervisory authorities highlighted the fact that the company is not having any transparency in a way they are collecting the data in order to feed the algorithm of their AI. There is a lack of legal basis for the processing activity. So that means that the company is not really relying on the proper legal basis of the Article 6 of the GDPR. And there are like other topics like the fact that they are not providing any access specifically for minors. So they need to ensure that minors are highlighted as such in order to ensure that they are not having access to some of specific information. But I will not focus on this one. If we are focusing on the transparency and the legal basis issue, we can already understand that here we have like different articles from a data protection perspective, which are not fulfilled. So the Article 5, which is all the principle related to data protection. Article 6 is the legal basis. And then the transparency, which are the Article 12, 13, and 14. So here, that means that from an AI developer company perspective, they are not able to provide a proper legal basis to process the data. What they did is that they said that is their legitimate interest to process the data to feed the algorithm. But the issue is that, for instance, if we are taking Replika, Replika didn't perform the legitimate interest assessment. So they was relying on the legal basis without performing the mandatory assessment behind to see whether or not there is an imbalance between the legitimate interests of the company and the right and the freedoms of the individuals. So here, that means that when they say to the supervisory authority that they are relying on that, they were not able to prove that before the control, the assessment was performed. So they provided the assessment, but only following the control. And they were performing a DPIA as well, but same, the DPIA was rejected by the supervisory authority because they said that we cannot rely on this DPIA because the DPIA was not accurate. So here we can see that, of course, there is an issue. And if we can highlight, Replika had a sanction of 5 millions and OpenAI had a fines of 15 millions. So it's not like small fines, it's really huge fines. And for each of them, as the sanction was really really bad sanction and the supervisory authority implement before the implementation of the sanction, a period where they need to be compliant. And for this period, if they are not compliant, they are asking them to pay something on a monthly basis in order to change everything very quickly. So already we can see that supervisory authorities starting to check, they start to check directly in the company creating the AI system. So for the time being, they're not really focusing on company using AI system because they would like to go like at the basis, the roots of the AI to ensure that then company will be able to use it properly. So already here we can see that there is a conflict between the GDPR and the AI, the use of AI and the development of AI.
Yes, I see how this could be challenging. As you said, there's a lot of data collected and used. You don't always know for what extent. And then, as you said, it's important not only to make a point or reference to specific possibilities, but also to assess to what extent this is true and have quality data. But this makes me think that it would always be a challenge for new technologies because you still don't know how exactly you would use it and to what extent this would be considering the challenges and opportunities for the users. How are companies balancing this AI innovation with compliance and ethical considerations? How are they navigating conflicting priorities in practice? Is it something that development is first kind of a survival, or is there any methodology that you have seen working?
So here I would say that depend of the company and depend of the localization of the company. Because if we are like really focusing on AI, we all know that Europe already implement a framework. So the AI Act in order to ensure that we are developing AI in an ethical way and transparency way from an individual perspective. If we are focusing on US, for instance, and Asia, like China, for instance, they didn't implement any framework because their goal is to ensure that AI will work like as better possible. And then after that, when everything is developed, then try to frame a little bit what is in place. It's like two different ways to see how the AI evolution is taken into consideration depending of the country where it's developed. It's of course one of the reasons why a lot of AI companies are located in US and China, because there is less restriction. But in any case, they will have, if they want to, then their AI system being used in Europe, they will have to implement the framework that was implemented. So here for company, the complexity is to really know first what is the goal, the aim for them to use an AI system. Is it just to be part of the trend? Because we all know that a lot of companies are just saying, yes, we will invest in AI and stuff like that. But behind, there is not really any goal, no purpose, no really like reasoning behind. And it's just because they want that everybody knows that they are like in the innovation part of this AI innovation. So here it's quite complex for those kind of company, because then it will be very complicated to prove and to explain the reasoning behind the purpose of the processing activity and the goal, all those topics that from a data protection perspective, it's mandatory to provide before to use the AI system from a transparency perspective for the different individuals to be able to understand what we are doing with their personal data and to assert their rights. So for those companies, it's more complex. And then there is some company where they are willing to develop their own AI system in order to really have some specific goals, use cases, purpose within their company to implement the AI to improve the efficacy, improve the way that they are providing services, to improve the way that the data is protected. So they have a goal behind. So for those companies, it's easier to manage because they have the purpose. And if they have the purpose, then they will be able to be transparent. They will be able to implement the proper legal basis. They will be able then to assess the organizational and technical measure that must be implemented in order to protect the processing activity and the data process. So for those companies, it's easier. Then you have as well the company which having a purpose, but using service provider for that, not developing their own AI system, but service like using ChatGPT, using Replika, using like service provider in order to provide the services that they need internally. For this one as well is complex, because then that means that the company is having the choice to provide their personal data to a third party, which will use this personal data to feed the algorithm, and all the data which like feed the algorithm will then be used for other companies. So here we have different risk, which is highlighted, the risk that you are losing the power on your asset, your personal, your information asset. You are losing as well the capacity to ensure the confidentiality of the data, because you don't know what will the service provider will collect, except if, of course, you are implementing all the measures, putting the siloed, ensuring that data which are provided in the system are only the data which the company is accepting to provide, which is quite complicated, because when you're working in the company, you can have like 100 employees, and you cannot be next to each of the employees. So you can train your employee, which is mandatory. You can explain them the risk. You can tell them everything you want. But if the employee is in front of his laptop, putting information in ChatGPT, copying a document in ChatGPT and asking a summary, or copying a document and asking a translation, you are not here. So you cannot like really ensure that everything we are putting in the service provider AI system is only what the company is accepting to share. So there is a lot of different risk, and from a company perspective, it's complicated to balance all those risks with the improvement that the AI will provide to the company.
That makes me think that indeed data protection is, let's say, it's more mature than AI, but also there's a lot of interference of AI on data protection. The impact could be negative, but maybe it could also be positive. Through AI, we might be able to enhance data protection and privacy. Are there some cases that you could share already seeing a positive impact of AI? And do you see any possibilities for them, AI and data protection, to converge in a positive way?
Yes, we all know that AI is the future. So we cannot do without AI. If we are too late in the development, the use or whatever on AI, we will be late in the development of the world, because we know that it's something which is quite important. We can take as an example the countries which doesn't have access to internet. And we saw a balance between like country having access to internet, they are like really evolving, improving everything, and country which and internet is not available, where people are struggling, they are not developing, companies are like late and stuff like that. It's the same for AI. So of course, AI, there is some like challenges, but in any way, AI is something that we need to work with, we need to use. And for instance, from a data protection perspective, we know that AI is really good to for all the repetitive tasks. And it's good as well for the summaries. It's good for the analysis when it's like really objective. From a data protection perspective, we need to understand how personal data are handled within the company. So here, of course, I am more like talking about the AI which are developed internally in the company. The AI can be a really good way to assess the flow of the data within the company, in order that from a data protection perspective, we know where the data is coming from, where the data is going, and where the data is finishing. It's as well very good. Same from a translation perspective. When we are working in international company, we have a lot of different languages that we are using. So it can be, and same from a supervisory authority perspective, we need to discuss with the supervisory authority, and sometimes we need to discuss in the language of the supervisory authority, which not everybody is like multilingual people, but AI can as well help on that. AI can as well help for the assessment of which personal data the company has. If we are training properly the AI system, they are able to tell you, okay, this is your data dictionary. You have name, surname, date of birth, address, phone number, IBAN number, and they can assess everything because you said to the AI, okay, this is a name, this is a surname, this is. It could be challenging when you are in an international perspective, because sometimes name, surname are like quite complicated to assess depending of the country. But at least it's an help, because the DPO, the team around which are supporting as well the DPO, the data management team, and all those teams, is mandatory for them to know which personal data they are handling within the company. And the AI system can help as well for that. So there is a lot of way for AI to support, to help data protection as well, even though there is sometimes like some challenges. But at the end, when the challenges are fixed, when everything everything is clear, when the purpose is defined, when everything is transparent, that everything is assessed, and that we are ensuring that there is no biases inside of the AI algorithm, and that it's checked regularly, that processes are in place, governance is in place, AI system is a support.
Yes, yes. No, that made me think because, of course, we focus more on cybersecurity here in the channel, and AI usually we say is the same, using to monitor, to be able to know what is happening in your environment. But when I think about data protection, I also see how AI could be used indeed, not only translating the language, but communicating to the user. We are data protection officers and cybersecurity professionals are not known for the best, as the best communicator to the user. So that could also improve a little bit awareness and understanding between the user and let's say the legal and security terminology. But that also makes me think in security, we often sometimes have to supervise, for instance, employees or the internet for specific data leaks. Is there possibilities that you see of conflicting laws, like one security requirement that you need to comply with might also go a little bit against the GDPR, or do you also see probably regional conflicting requirements, and how companies can manage this? Is there hierarchy of legislation, or how can they understand what is at stake and what are their options?
Yes. So from an AI perspective, I would say that if, for instance, we are taking as example the AI Act, it was created in order to not conflict with the GDPR. It's created in order that the GDPR is a basic where the AI should be created. So we saw that in a lot of different regulation or directive where the first sentence are all the processing of personal data should be compliant with the regulation, the GDPR. And then you have the other rules, which are like in addition of everything that needs to be implemented from a data protection perspective. But sometimes, indeed, there is some conflicting regulation. Is the case, for instance, when you are working in an international scope, and that you have some of the regulation in US which are conflicting with the regulation in Europe, and same for other countries which are outside of EU, for instance, and where you have a lot of regulation which are like I would not say hiding stuff, but doing things without being transparent about the way that they are doing it, which is conflicting with the GDPR, where GDPR and AI Act is the same. The main goal is the transparency. So we can see that. We have as well the same issue, which is less related to AI than other regulations, all the AML CTF regulation, where they are collecting a lot of personal data from a public interest and legal obligation in order to check and ensure that we will not have any anti-money laundering, counter-financing of the terrorism. But in a way, it's a little bit in a, I would say, fight with the GDPR, where we are highlighting the minimization principle, where we are saying that we should collect as less personal data as needed for the purpose of the processing activity, and that we need to have a legal basis for each of the data. But as for from an AML perspective, it's a risk-based approach. A lot of companies are asking more and more personal data because their risk-based approach is really high. And so they would like to have as much data they can in order to be able to check properly and to prove that they perform their check. So, and here it's two regulation where the goal is for one protect individual, for the other one it's more protect company, and for both of them the fines are really high. So it's quite complicated for company to find a balance for this kind of regulation, where indeed AML it's a little bit on top of data protection because it's a public interest, and the GDPR it's a little bit below, but it's not avoiding the company to follow the GDPR rules when we are following the AML rules. So indeed, we are following the AML rules, but we need just to ensure that, okay, we are able to explain why we provided this personal data, why we are collecting this personal data, to document the legal basis in order to be able to prove that we are doing, to be transparent with the individual and explain which personal data we are processing from ML perspective. So that means that GDPR it's a regulation that, from my perspective, is not really against other regulation. It's a regulation where it's forcing the other regulation to be more transparent, to document things, and so to be like more, I would say, more strict in a way that we cannot do whatever we want like that, saying, oh no, but I have a legal obligation. Yes, but still, you need to document, to be transparent, to show that you collect only what you needed, and so to give a frame for the processing activity.
Yes, if I can summarize it, GDPR is not meant to be a block, but it's meant to be the basis, and you have to pull, let's say, every time to the direction of protecting the user in the activities that are
Exactly.
needed for your security or other legitimate interest. Very well explained. Thank you very much for that. That makes me think you spoke a lot about transparency, but I'm thinking also we spoke about companies, right? Their legitimate interest. Much of the AI today we see being adopted in also public interest in healthcare, in government services, finance as well. We discussed. What are one can imagine there is a high risk, right? The healthcare data, something biometrics, you cannot change like a password in the in your email or IBAN of your card. So there is a lot of risk for the individuals linked to this specific data processing. What are the safeguards you would recommend in such cases to be used when starting adopting AI for these more critical sectors?
First, I would say that the first thing that the company should do is to ensure that the processing activity that they are doing in healthcare, finance, public service, or whatever the sector they are working is not part of the prohibited AI use. Because in the AI Act, we have clearly the list of all the prohibited AI use, and it's indeed impacting all the sectors where potentially the risk on the individual could be too high, that this kind of AI system, and the AI Act is saying like properly that they are talking about AI development, but as well AI use of the system for those purpose, that is prohibited. So it's the first thing to do for a company is to ensure that they are not entering in the category of the prohibited AI. Then after that, they need to see, okay, then there is a list of high risk AI processing, and then they need to check whether or not they are entering as well inside of this one. If what they want to do is like potentially entering in the high risk AI use, then they have to discuss and to see how to change the purpose of their processing activity. Is it really needed to check the mood of the person who is sending an email? Is it really needed to perform a facial recognition of the person and to check whether this person is happy or not? I don't think so. I don't think that for some of the use of the AI, it's really needed. It's not needed. Then what the company needs to do is to really ensure that they are understanding the reasoning behind they want to use the AI system. What is the goal? What they want to deliver? What they want to have within the company, and how really AI will support to provide that. We are talking a lot about AI, but there is a lot of other systems which are not using AI, which maybe could deliver the same results and with less risk and less impact in the individual. So this point is something that with the help of the DPO, it should be assessed within the company, because when we are, for instance, relying on the legitimate interest, is one of the topics that we are saying, can I deliver the same result with another way? So am I obliged to use AI for that? So this is one of the point. And then after that, if indeed AI is needed, then we need to see, okay, what are the impact? Is the reason why with AI, the AI Act is saying that in addition of all the assessment that from a data protection perspective are mandatory, so the DPAA, data protection impact assessment, legitimate interest impact assessment, if we are relying on that, the consent assessment in order to ensure that it's valid, freely given, and like that it can be withdrawn at any time and stuff like that. This is the data protection part. But the AI Act is saying that when we are using AI, it's mandatory to perform an assessment regarding all the right and freedom of the individuals. So it's not only focusing on personal data, it's focused on all the potential rights and freedom that the individual might have, and to check whether or not the use of the AI system could have an impact on this right and freedoms. So it's all those points that the company should do. And then after that, with all those assessments, then they must document everything to ensure that in case of control, they are able to prove, like, which is one of the points that Replika had an issue with that because they were not able to prove that they did it before to use. So documenting everything. And then after that, working like step by step and ensure at each step that they are still aligned with the assessment that was performed, because this is one of the things as well, to maintain the assessment ongoing, ensure that on a yearly or 2 yearly basis the assessment is renewed, to ensure that if there is like improvement, modification on the AI system, evolution on the AI system, new collect of personal data, if the assessment is still valid, are we still having the capacity to protect the individuals or not?
Yes, yes. I was smiling because all this document, and assess the impact seems like what I see people using AI most for. Is AI actually assessing its impact on people and individuals? Probably very much so, as long as it does it how convincingly. I think this is also helping the data protection activities. But in that sense, do you see any legislation or policy developments that are needed in the midterm to address any of the potential gaps or of the conflicts of law? Are there maybe industry standards you see necessary to guide also companies in secure data protection with
I
AI?
think I think that it's quite complex to add again another layer of regulation. So for this one, it's complex because we are having a more and more regulation, more directive to follow. And when we are in an international context, it's more complicated because in addition of all the European regulation, we need to take into consideration the local and the regulation of other countries. So it's quite complicated. I think that maybe which would be more efficient and needed, it's guideline regarding the already in place regulation. So for instance, for the AI Act, we were talking about the assessment regarding the right and freedoms of individuals, but we don't have anything we can rely on for the time being. So having, for instance, a guideline for this kind of assessment, the list of all the right and freedoms that we should assess, for instance, some examples of impact that the AI could have in order for company to as well have an assessment which will be aligned from a company to another one, because assessment is always very personal in a way that company are assessing what they think that is relevant for them, but maybe it's not what the supervisory authority is expecting. So it's one of the risks. Or maybe having like more guidelines on regarding the way we are using AI. If, for instance, I know that it's ongoing. There is a lot of different public authorities and organizations which are starting to work on different guidelines and different framework for company to be able to work under the same frame and to have something more standardized. So it's still ongoing for the time being. So let's say that it's more this which is needed than new regulation or adaptation of the regulation. One of the fear that I have is that already, for instance, from a GDPR perspective, we are talking about amending the GDPR, make it lighter in order to align, for instance, with US, in order to align with other regulation. But from my perspective, I don't think that we should decrease what we think that is good in order to align with other regulation. From my perspective, we need to ensure that other regulation will more try to reach the best than try to decrease their goal. So here is the same for AI. The risk regarding AI is that we are saying, okay, from a GDPR perspective, what is requesting is too complex if we want to implement properly the AI. Same for AI Act. What is inside of the AI Act is too complex in order to move forward faster from an AI perspective. But I think that it's a question of adaptation. At the beginning for GDPR, everybody was saying, oh my gosh, it's complex. We don't know how to do and stuff like that. But now people are managing. People are, yeah, sometimes we still have some like little conflicts we need to discuss. Supervisory authority are here as well to support, to tell us, okay, what is their point of view regarding this point and this point. So we can manage. And so I think that really from a regulation perspective is the same, not having new regulation, maybe just give us more clarity on what is requesting on the ongoing regulation and ensure that we will not decrease our standard in order to align with other countries where some, for instance, there is no standard at all.
Mhm. Yes, no, very inspiring. Thank you so much, Aisato, for sharing with us. And if you liked this chat, you could check the book of Aisato that is on the balance between personal data protection and clinical research. Aisato, where can our viewers find your book?
They can find it on Amazon.
On Amazon, great. And also, Aisato is available for board level advisory on data protection or data issues. So don't hesitate to reach out to her also for any further speaking opportunities. I thank you very much. And I leave our audience to leave their comments, questions also in the chat section so that we can address them as they come.
Thank you very much, Eva, for inviting me. It was a pleasure.